Hopefully I've estimated the amount of time right. Okay, torts displaced by crimes in the early 18th century. This is a slightly overstated title, and we'll come back to the question of how far it's an overstated title a little bit later. In Michaelmas term 1716, the Court of King's Bench heard argument in Garner against Anderson on a motion to amend the plaintiff's declaration in Replevin for a cart and 4 horses. Sergeant Hall for the plaintiff explained the circumstances of the case. The fact was that a servant of the plaintiff's was driving a cart, and by chance he ran over and killed a child, on which the defendant seized the cart and horses as a deodand, and the servant was tried for the murder and found per infortunium, by accident. This looked odd to me, but on investigating a little further, it turned out that it was routine practice from the beginnings of the Old Bailey Sessions papers in the 1670s down to 1750 for drivers involved in fatal road traffic accidents to be prosecuted for murder. There is about 1 case a year in Old Bailey Online until 1750, when they abruptly disappear. There is no case in which the driver was actually convicted of murder, though a couple in which, on the modern view of the offence, this might have been possible. For example, the coach driver who in 1710 ran over a beadle who was serving as a parking attendant and asked him to move his vehicle. Commonly, drivers were acquitted or found to have killed per infortunium, as in Garner and Anderson. In a minority of cases, they were found guilty of manslaughter. This was what happened to the coach driver who ran over the beadle. And in a few, they were found guilty of chance medley, presumably on the basis of Sir Matthew Hale's understanding of this offence as homicide which was merely negligent. Now, of course, there was no tort liability for killing until Lord Campbell's Act in 1846 abolished deodand and created the acts in 1846, abolished deodand on the one hand and created the Fatal Accidents Act liability on the other. But this practice of prosecution of accidental vehicular homicide forms part of the background of the Hackney Coaches, etc. Act 1715, Section 8. The preamble states in the usual inflated terms that whereas through the negligence of carters, draymen, carmen and waggoners riding upon their carts, drays, cars and waggons in the streets of London and Westminster, the borough of Southwark, and other streets within the weekly bills of mortality, aged and other persons and children are frequently maimed, wounded and killed. The section then goes on to provide that carters and so on operating within the bills of mortality, London and suburbs, are to have some person leading rather than driving their teams on penalty of 10 shillings, between 1 and 2 weeks' wages for a coachman at this period. I guess probably a higher proportion of wages for a carter or dray driver than for a coachman, or 3 days hard labour in the alternative in the event of non-payment. This act in turn feeds into Section 7 of the Continuance of Acts, etc. Act 1754, generalising the liability beyond London and extending its provisions. And whereas many bad accidents happen and great mischiefs are frequently done upon the streets and highways by the negligence or wilful misbehaviour of persons driving carriages thereon, be it therefore further enacted that if the driver of any cart, car, dray or waggon shall ride upon any such carriage, not having some other person on foot or on horseback to guide the same, such carts as are respectively drawn by 1 horse only or by 2 horses abreast and are conducted by some person holding the reins of such horse or horses excepted, or if the driver of any carriage whatsoever on any part of any street or highway shall by negligence or wilful misbehaviour cause any hurt or damage to any person passing or being upon such street or highway, then penalties are incurred. The basic penalty remains 10 shillings. There's no change in the value, no significant change in the value of money between 1715 and 1750, so we can't make that isn't being eaten away by inflation. But the alternative is now raised from 3 days to 1 month's hard labour, and the offence is made arrestable without warrant. Here, unlike the homicide prosecutions, criminal liability is unequivocally being added by statute to an existing tort liability. This criminal liability for causing injury or damages through negligent driving is not the clearest example of my subject, which is the apparent predominance of criminal remedies over equivalent tortious ones in reported cases in the post-revolutionary and early Georgian period. I've started with it because it was for me the most unexpected. Libel appears in the 1690s as a crime, and initially as seditious libel before the appearance of blasphemous, obscene and defamatory libel. But defamatory libel in the law reports down to 1760 continued to be predominantly prosecuted by indictment or information. Nuisance had a very long history in civil proceedings, and actions on the case with matters which we would now call private nuisance continued. But, quote, nuisance, unquote, in the law reports meant predominantly indictments or informations for public nuisance. Indictments for forcible entry and forcible detainer allowed the trial of land titles at quarter sessions. Riot could also be used for this purpose or used as a form of aggravation on simple trespass claims. Norma Landau showed in 1999 that a great many battery claims at quarter and petty sessions were brought with a view to settlement, thus offering an alternative to civil claims in trespass to the person. A good deal of the territory now covered by economic torts, quote, economic torts, unquote, was indictable as conspiracy, but civil actions for conspiracy were rather rare in the reports in this period. What I propose to do is to talk a little bit further and go a little bit further into depth about libel and nuisance, perhaps to talk a little bit about forcible entries. I'm not sure if I will have time, and related matters, and then go on to speculate a little bit about why the reports may be showing us an apparently greater interest in prosecutions for misdemeanors than in civil actions which might be available on the same facts. I emphasize again that what I'm primarily concerned with is patterns in the printed reports. I haven't been digging up in the records the frequency of actions on the case for nuisance versus indictments for nuisance or any of these other things. I start with libel. It is, of course, familiar that libel has antecedents going back to Star Chamber, and King and Lake in 1670 is usually treated as the starting point of the differentiation between slander and libel at common law. The pattern of the reported cases is slightly different. In 1689 to 1702, the only reported cases to use the expression, quote, libel, unquote, are cases of seditious libel. In the reign of Anne, there are 11 cases, including one of obscene libel rejected, and 2 which might be considered as defamatory libel, but nonetheless have some public admixture to them. Langley in 1704 was indicted for saying of the Mayor of Salisbury, "You, Mr. Mayor, I care not a fart for you," and on another day, "You are a rogue and a rascal." the indictment for these spoken words was rejected. But Chief Justice Holt said obiter, if the defendant had abused him in writing, that would have been indictable, for that was a libel, and the mayor might also have had his action. There was one action on the case, not clear how far it's libel or, well, it is libel in our modern terms, but it's a little bit ambiguous in the way it's expressed. Anonymous, for accusing the claimant of saying that, quote, he could see no probability of the wars ending with France until the little gentleman on the other side of the water, the old pretender, was restored to his right. This is defamation, but it's very much about political speech rather than about general character. In the reign of George I, there are 14 cases. Only one of these is an action, and it's an appeal to the Privy Council from Barbados. But in this period, it becomes clearer, particularly from the 1720s, that indictment or information was available for purely defamatory libels. There are 5 cases of seditious or treasonable libel, and one of blasphemous libel in relation to Unitarian publication. The remainder being apparently of defamatory libels. For a couple of early examples, Richard Bentley in 1723 prosecuted successively a bookseller and one of his colleagues, Dr. Middleton, for a libel on him contained in a Latin preface to a history of Cambridge University Library. The result of these proceedings was presumably to give the libel much more publicity than it otherwise would have had. In the same year, the Mayor of Northampton was prosecuted for libel for sending to the Earl of Halifax a license for him to keep a pub, which the court said was a libel in the case of a person of his quality. In the 32 year of the reign of George II, there are 37 reported cases. 6 are on seditious or treasonable libel, 2 on blasphemous libel, 1 on obscene libel. I should say that this is the celebrated case of Edmund Curll, and it actually began under George I and carried over into George II. And 5 on forms of contempt of court by publishing. 2 have unidentifiable subject matter. But 17 are indictments or informations on defamatory libel. In the same period, there are 4 reported actions on the case for libel. One of these was mixed with malicious prosecution. In the end, it was unsuccessful, and it was followed by a prosecution of one of the parties. 2 of them are at the very end of the period. It looks perhaps, I say this with highly speculative thought, as though there may have been a movement back into actions on the case actions on the case for libel under Lord Mansfield, starting in the late 1750s. But I say that with with considerable hesitation. The preponderance of prosecutions relative to actions is striking. The preponderance of defamatory libel among the prosecutions is less extreme, but also, I think, still notable. It should perhaps also be noted, however, that Chief Justice Reeve in 1736, arguing about words in slander, still seems to have thought of libel as mainly about seditious libel. So he said, words are not so strictly construed as heretofore, and there is good reason for it, since discouragement of actions for slander will encourage revenge in another manner. A libel is sufficient when alleged to be of and concerning the king and government, the ministers, etc. The other is matter of evidence, whether the words concern them or not. To turn now to nuisance. It's had a long history, both on the civil side and on the criminal side, before the period with which we're presently concerned. And a good many points of nuisance law were adverted to in argument by way of analogy in unrelated cases. We can, however, get some indication of the relative presence of actual cases in the reports. In 1689 to 1702, there were reported 8 prosecutions for public nuisance, 2 actions on the case for public nuisance, 4 actions on the case for private nuisance, 1 quod permittat pro sternary in common pleas, startling, 2 cases arising out of self-help abatement, and 1 proceeding in equity for an injunction. In 1702 to 1714, the balance of reported cases shifted more towards prosecutions among smaller totals, with 6 prosecutions, 1 action on the case for private nuisance, and 1 issue arising on self-help abatement. This pattern continued in the reign of George I, with 8 prosecutions, 1 action which on its facts was argued that it should have been case for private nuisance, the famous case of Reynolds and Clark, actually brought as trespass, and 1 proceeding in equity for an injunction. The longer reign of George I showed a continued predominance of prosecutions for public nuisance, 25 reported cases, as against 1 action on the case for public nuisance and 3 for private nuisance, and 3 cases arising on self-help abatement. But from the 1740s, there was a sharp rise in reported cases on proceedings in equity for injunctions, 9, of which 2 were in 1729 and 7 between 1744 and 1755. I should emphasize, I think, that the large majority of the indictments or informations for public nuisance are perfectly conventional public nuisance cases, in particular interferences with the highway and a rather smaller number of interferences with waterways. Some of them look like willful injury to the highway, and in particular probably forms of sabotage of turnpikes, which gave rise to a considerable amount of resistance by way of criminal damage to the introduction of the turnpike tolls and conflicts, and as a result actually damaging the turnpikes, damaging the gates and toll equipment, damaging and so on, became felony by statutes. However, a number of them seem to slide close to private nuisance. For example, Whig in 1705 was convicted for keeping hogs in London, here in town in some of the back streets, presumably only a nuisance to his immediate neighbours. Smith in 1726 was convicted on an indictment for making great noises in the night with a speaking trumpet to the disturbance of the neighbourhood, which the court held to be a nuisance and fined the defendant £5. Indeed, in Clark in 1702, it was said not to be an objection to a witness in public nuisance, that this public nuisance was also to his private nuisance. In relation to forcible entry and related matters, I'm going to have to shift slightly backwards in time before my period, because of trying to understand what the hell was happening. There was certainly a lot of proceedings for forcible entry in the 1760s. And in the 1770s, both Sir Matthew Hale and Lord Nottingham complained that the consequence of the use of forcible entry was that title was being tried at quarter sessions, and that this was an unsatisfactory way of proceeding because you couldn't get clear what the actual title in dispute was. There was no mechanism for pleading, no mechanism for making sure that the relevant documents were in place, and so on. The courts went to and fro over the question, should we allow, how far are we concerned in forcible entry? This had been going on for quite some time. The statutes are medieval. How far are we concerned in forcible entry just with the force? And how far are we concerned with the title? Again, hail a question mark over. How far is this real force? And we get applications of the Statute of Elizabeth, which says that 3 years prior possession is a defence to a charge of forcible entry, an indictment for forcible entry. But what does prior possession mean here? Prior to the force? Prior to the date of the indictment? Moreover, to what it's necessary in forcible entry, it becomes necessary in forcible entry in the indictment to say what estate the complainant had before he was deceased or ejected as a result of the forcible entry. The reason being because it had been established at a very early stage, fairly early stage, that tenant at will, ejection of tenant at will, didn't come within forcible entry. But there's a problem here. In the 1680s, it turns out that the ambassador of the Duke of Savoy took a house as tenant at will. This was a temporary embassy. The ambassador of the Duke of Savoy took a house as tenant at will, and then his landlord committed a murder. And the High Bailiff of Westminster and his under bailiffs came and seized the house and seized the furniture and evicted the ambassador and his officials, the consequence of which was that complaints were made by the whole body of diplomatic representatives to the king. And Sunderland wrote to Scroggs, Chief Justice Scroggs, demanding that he should give effect to the statutes against forcible entry and make sure that the ambassador is restored to his property, because otherwise it's going to be very seriously problematic for Her Majesty's government in its dealings with the foreign ambassadors. The High Bailiff is duly convicted in spite of the objection that the ambassador had merely tenancy at will. And how do we deal with this? The answer is, rather than using the expression forcible entry, we use the expression riot. As long as there are more than 3 people, an entry which is wrongful can be said to be a forcible entry, and being wrongful, therefore a riot. And such cases continue. Forcible entry as such, because of the ways in which the court has imposed rules on it, which mean that you do actually have to recite something about the title, and there are this limits and that limits and so on. Forcible entry actually rather dies away in the course of the 18th century. But indictments for riot carry on, and indeed we begin to see, as I said earlier, no, I haven't said this yet, but I'm going to say it, the court is unwilling to quash indictments, particularly is unwilling to quash indictments for nuisance, and it's also unwilling to quash indictments for riots. But we find that the court is willing to quash indictments for riots where the riot turns out to be a trivial dispute about what's actually merely a property dispute. If it appears on the facts that this is merely a property dispute, the court will, in certain circumstances, quash the indictment for riot. So the problem is persisting. It persists, in fact, even later into in the late 18th century, well beyond my period. Mr. Justice Buller was concerned about parties trying title not in quarter sessions but in petty sessions by prosecuting the current possessor of land for shooting game without qualification on the ground that they don't own the land of which they're currently in possession. Yes, the problem, I think, is more acute even than trying title at quarter sessions on forcible entry, or for that matter on riot. Explanations. What explanations are possible? It's relatively easy to give a specific explanation of why complainants might have wanted to prosecute for libel rather than bring an action. In the first place, it's clear that the courts were very much more liberal about the question of reference to the complainant in indictments or informations for libel than they were in actions for words. Thus, to give an example of something which I think most people probably approve of, in Osborne in 1732, the defendant published a variant on the traditional blood libel story as a piece of fake news against Portuguese Jews who had recently come to the UK. He was prosecuted in spite of the objection that there was no clear single person who was referred to as defamed in this defamatory libel. On the other side, perhaps less desirably, in Genoa in 1740, an attack on an unidentified East India Company director as allegedly raising the price of tea by burning surplus supplies could be prosecuted as defamation of the East India Company and all its directors. Secondly, and probably more importantly, truth was no defence in an information or indictment for libel. This will certainly have been beneficial to the York Buildings Company, who were able to prosecute Canute in 1732 for publishing allegations of a share price ramp, which were very likely to have been true. The company was, in fact, subject to a parliamentary inquiry and bailed out in the same year. The doctrine was not entirely comfortable. In Bickerton in 1722, where the person allegedly defamed admitted the truth of the allegation on the record, the court didn't wholly prevent prosecution, but refused an information, so that the complainant was then going to need to get a grand jury to support him in order to get an indictment against the defendant. Later judges, however, stuck with the idea that information was available, even if there was very strong evidence to believe that the allegations were true. In Roberts in 1734, counsel argued that the consequence of this rule was that by allowing informations in defamatory libel, the court was depriving the defendant of the right to justify which they would have in an action on the case. Lord Hardwicke, I think, probably pressed for some argument to give in relation to this issue, said that truth was also no defence in an action on the case for libel, unlike slander, but that in the action truth could be led in mitigation of damages, and in the prosecution it could be led in mitigation of the fine. It's far from clear that this view became more widely affected. We may similarly see specific reasons why complainants might have preferred to proceed in public nuisance rather than bring case. In the first place, in the action on the case, there was an inherent risk that the nuisance would be found to be public and the claimant to have suffered no special damage. Thus, for example, in Iverson and Moore in 1698 to 99, where the defendant had in fact intentionally blocked the claimant's access by blocking the public highway in such a way as to block customers from getting to the claimant's mine. Nonetheless, no special damage because this is just blocking the public highway. Prosecuting in the first place for public nuisance was much lower risk on this front. In Home in 1694, the Court of King's Bench quashed a nuisance indictment on the ground that the nuisance charged was ex facie private. Later, however, the court took it to be a general rule that it would not, except in exceptional cases, quash indictments for nuisance. Instead, the defendant would be put to demur, requiring them to admit the facts in order to contest the legality of the indictment. Secondly, the charmingly named 1726 case, reported in Sessions cases as Papinian, almost certainly more accurately by Strange as Papineau, tells us that it was normal, though not absolutely required, for judgment in public nuisance to include an order for the abatement of the nuisance. This would be a very substantial saving in costs, given that an action on the case for nuisance would give only damages, and it would be necessary to proceed in equity for an injunction, very probably already possible by the 1650s and certainly available by the 1690s. But already by 1705, Chancery had become notorious for delay and cost, which formed a part of the motive for Somers' Act for the reform of the law in that year. So if you could get the nuisance dealt with altogether by the criminal proceeding, it would be greatly preferable. So here's Strange as reported in Sessions cases. Sir John Strange, in support of this objection, argued that the intent of indictments for nuisance was to have an end put to them by one suit and to avoid multiplicity of actions. And it is upon this reason that an indictment for a public nuisance is given before an action on the case, because it makes an end of things at once, which is not done by giving damages in a civil action. I flagged earlier that what I'm discussing here is patterns in the reports. It is possible that this is all that we're seeing. Clearly, a lot of the reporters' efforts which went into common pleas before the Civil War and interregnum shifted into Chancery from the Restoration, with the result that common pleas was erratically reported and continued to be erratically reported until the late 18th century. It may be that masses of actions on the case for private nuisance are taking place in common pleas, and that this dominance of indictments for public nuisance or actions on the case, quote, for libel are taking place in common pleas, and that these this dominance of public prosecutions, which we're seeing in the reports, is an effect of the dominance of King's Bench among King's Bench and Chancery among the reports. I have a little bit of a hesitation about that, as certainly it's a possibility. I have a little bit of a hesitation about that because it may be that if we ask the question, why are people not reporting common pleas? The explanation may well be that the business that common pleas is doing is boring and not as interesting and not as remunerative and lucrative as the business in Chancery, not as lively and controversial as the business in King's Bench. On the other hand, there is another possibility, which I think is also reflected as is in a sense supported by the availability of indictments for battery and criminal proceedings for negligent homicide and by the availability of forcible entry and riot as a substitute for forcible entry, which is less technically constrained. And indeed, the end of the century attempts to try title in petty sessions by prosecuting for shooting game without a qualification, which I must admit I think is pretty clearly an abuse. The context of all of this, it seems to me, is perhaps costs. Papineau indicates quite strongly that there's a costs and delay issue. We're getting quicker results by proceeding criminally and less expensive results by proceeding criminally in nuisance than we would get by proceeding civilly. It seems likely that the same is true of indictments for libel as well, that you're going to get quicker proceedings and less in the way of fewer possibilities of interlocutory applications. And because fewer possibilities in the way of interlocutory applications, less costs than you've got on the civil side. If this is the case, perhaps we might think of this as interconnected to two phenomena, one of which is the Great Litigation Crash, which, as far as I understand it, is evidence primarily of a litigation crash in civil proceedings in the central courts. And secondly, the persistent, extensive, loud complaints about costs and abuse of delay and abuse of process at law and in equity among the pamphleteers of this period. So maybe this is what we've got is ad hoc partial solutions to get round the costs problem. Maybe we've got something, as I said, maybe it's something a lot less. Maybe also the other side of it, there's a connection with the point that David Lemmings and others have made, that there is a shift in the legal culture in the 18th century into verticality, which is reflected in the increased importance of statute, in the very considerable increase in criminalization by statute, of which, in fact, I've just given a couple of examples of the criminalization of drivers. So these range of possible, I won't say anything more than that they're possible explanations. What I've been talking about is a pattern of criminal proceedings equivalent to civil proceedings, but more of the criminal proceedings than the civil proceedings in the law reports. Thank you.